Good morning, good morning, good morning, everyone. Welcome to another episode of Spilling Tea. I'm your host, Tiffany Daniels, and we are going back to that horrible world known as the JRC. But before we do the new shortened disclaimers, I'm coming to you late this morning because yesterday I went to the Fall Festival at Silver Dollar City, obviously. Get the shirt. Actually, it's a pretty nice shirt. I'm sorry I look like crap, but I did literally just get up not that long ago. So apologies for my not so great appearance. All right, folks. So, in the description box, you are going to find all the links that are pertinent to the Stop the Shocks campaign, as well as the situation out in Agape boarding school. When you watch this channel, you're going to see surveillance footage of, as well as news articles and what have you, in regards to people with mental health issues and people with disabilities being tortured and abused. If you got young children present, folks, please use your headphones. Please note, in particular, the article put out on the JRC by NeuroClastic, for which they have been threatened with a defamation lawsuit they did not remove from the website. They have refused to do so, so please don't forget to read that article. Also, take a look at their response to the defamation lawsuit threat as well as their GoFundMe. They are a small group, folks. They are not carrying the type of funds needed to fight someone quite on the level of the JRC. All right. This channel is marked not for kids for a reason. We use profanity on occasion and we do speak on dark subjects. So if your child is 16 and younger and they are watching this, very obviously, parental supervision is very much advised. So we're going to go ahead and jump on into it. Try to make these short and sweet. Part of the court's reluctance to find liability under the 1983 is due to the belief that the plaintiffs would do better to seek relief under common law tort doctrines. So, what does that mean? This is, once again, what I've talked to you about before, that particularly out here in the US, you literally have some things that are literally laws from county to county. This is why we need federal laws that go across the board with very, very specific language. It's because county to county, it's a little bit of chaos, particularly if you're from a Bible Belt state or you're from a state that loves its pseudoscience, like in Massachusetts. Because more often than not, you have a large group of disabled people whose rights are literally never respected. Never respected. So leaving it up to the county laws, even as opposed to state law, you see what I mean? This is why so many folks who are disabled do not come forward in regards to abuse allegations when we are being abused, because you have these county to county little laws that do nothing to protect us and everything to protect the perpetrators, whether it's in the larger sense of a school setting or whether it is a caretaker versus disabled person. Let's go ahead and read on, shall we? Indeed, a number of children injured by the use of restraint and seclusion have sought relief by suing under theories such as false imprisonment, emotional distress, and medical malpractice. As might be expected, a number of these cases settle, thus rendering the actual legal status of aversives under these common law doctrines unclear to some extent. So let me lay it out for you. You can sue these people for the horrific, I do mean horrific, abuse and torture that they put you through. More often than not, the people who are disabled and our parents do not have unlimited funds to fight these non-for-profit organizations who bring in millions of dollars a year. They end up settling. So although the particular disabled person might be getting compensation, that leaves literally thousands of us unprotected because the law does not change. Okay? Now, let's bring it back to the fact that in these suing cases, more often than not, whether or not one succeeds in their lawsuit has heavily to do with the biases that are going on within their local court systems. The reason why so many end up settling is because A, difficult to prove to the satisfaction of the particular state whose biases you have to play to. And number two, usually the individuals that you are coming up against are backed by a corporation of some sorts. They have access to funds that you and me, we do not. So if you do manage to get some compensation, that's fantastic. But again, the problem is the laws do not change. You see where I'm going with this here, right? You see the glaring elephant in the room? It's a circle jerk, folks. It's a literal circle jerk. But this can be addressed by civil court. The problem with that is civil court and their judgment does not change laws. So that still leaves all of us unprotected. Yeah. Let's read on, shall we? For instance, the New York Court of Appeals in the aforementioned case of Peters versus Rome City School District upheld the jury verdict of liability for both false imprisonment and resulting negligent infliction of emotional distress against a school that had placed a child with disabilities in an unsanitary seclusion room 75 times in one school year. In addition to concluding that the school had intentionally confined the student and that the student had been aware of this confinement, the court emphasized the fact that his parents had not consented to the use of seclusion in his IEP. It further held that the jury could well have found that these interventions had endangered the student or caused him to fear for his safety, and that they were outrageous enough in frequency, duration, and manner to support a finding negligent infliction of emotional distress. So this is one of the rare cases. And folks, I cannot emphasize to you exactly how rare it is that these individuals were actually able to win this lawsuit. But as you read the language here, in spite of the fact that the civil lawsuit was won, did any of the laws change so that it would become that there would be more protection, more specific protection for the kids with disabilities that are going to appear after the ruling on this case? No. Nothing changed. And that's the problem. This is why we are gunning for more specific federal protections. Because where it is great that we have a few wins here and there, if the laws don't change, we're back at stage one every single time. It is very rare when you find an instance that a civil court case will actually change the federal laws. Just in general, forget disabled for a minute, just in general, it is very rare for when a civil lawsuit is actually won by the plaintiff who is bringing the suit actually changes federal law. Okay? That's the problem here. It's passing the buck. Okay? Which means in the end, although a specific one individual might be able to achieve justice, the majority of us remain unprotected. You see where I'm going here? That's why we lobby for more language-specific protections and why we're trying to get those 2 acts passed through. Because until that happens, you may get victories here and there, but the majority of us are basically walking, moving targets. And we're going to close out on that font. We don't get very many views on this channel. The few that we do tend to get removed from time to time. So folks, please don't forget to hit the like button, hit subscribe, and don't forget to hit the comments. I do appreciate your time this morning. And as always, folks, we here at Spilling Tea do hope you have a good one. Bye-bye, everyone.